May it please your lordship. May I crave leave of your lordship indulgence to adjourn the item 7, lordship. I have some personal difficulty, your lordship, today.
No objection.
Just for a week only, your lordship.
On premier by the seeking accommodation, the same not be objected to by petitioner. Matters adjourned. This is the same after 2 weeks.
Apply, your lordship.
Proceed. May I beg to mention item number 4, you will see.
Number 4.
Item 4. You will see, in this case, I supposed to produce the record, you will see. Record not yet reached.
What is this matter about?
Regarding this ACR,
ACR and promotion.
So the ACR has to be produced.
you will see, last question, this could ask me to produce the record, how this began the decision. So this record I have yet to be.
What is your ground?
My basic ground is that, your lordship, is that I've been superseded by my junior, that ACR does not been furnished to me, and most important ground which I have stressed, your lordship, is that after the disposal of this court, they were supposed to pass some speaking order. They have passed a speaking order without any findings, but the only finding was that if I am being given a promotion, it'll open a floodgate for other people.
How long?
2 weeks, you will see.
On premier by Mr. Archival Data, Learned CGC. This is matter to 2 weeks.
Your lordship, in item number 9, my senior counsel is there. Your lordship, item number 9, I'm supposed to file my affidavit, so my affidavit is already ready. Only the process of signing it, so I'll be filing it in by Monday
This
or
matter is
Tuesday.
posted in the hearing column.
Maintainability.
Oh, okay. Yes,
Your
now I
lordship.
record. So you are supposed to file the affidavit on
Merits.
the merits.
Your lordship.
How long?
Let the matter come up after 2 weeks.
So you are telling him to, giving him a
already
time
put
limit
the-
to file.
He's already put the words in my mouth.
So you will help him to draft the affidavit. On premier by Mr. P. Nongri, Learned Counsel for the respondent.
JHDC 1, 2, 3, and 6.
1, 2, 3, and 6 respectively, seeking time to file the affidavit, counter affidavit. Matters adjourned. This is matter of the 2 weeks.
Obliged.
May I please, your lordship, I beg to mention item number 3.
Number
3. Your lordship, let this matter come after a week, 1 week.
you're for
The petitioner, your lordship.
you're for petitioner,
Yes,
and you're asking for time. I thought it's the respondent who should ask for time. 2017 matter, miss.
Other respondents?
Yes.
Has this matter, was it ever heard?
Yes.
Disposed? Has it gone up, come down?
Down.
Naturally. Supreme Court? DB? No, I'm talking about, you see, the process. Whether the writ was heard, then it had gone for appeal, remanded.
It's not traveled anywhere. Pending for 7-8 years now.
Not 70 years, more. So,
Yes, your lordship. After 1 week.
pre-made by petitioner, this is matter to 1 week.
Highly obliged.
Lordship, I beg to mention item number 5, Lordship. I I'm praying for one week time, Lordship.
Respondent 3, my lord. Northmanship matter.
On premium by the petitioner, this is matter after 2 weeks.
Much obliged.
May it please your Lordship. Lordship, I beg to make a mention of item number 6, Lordship.
That's, my lord, that promotion matter.
Oh, what you are pressing the matter.
My lord, that DPC proceeding has to be given to the petitioner.
So DPC proceeding has to be given to whom?
My lord, by which the promotion has been denied with the 2 DPC proceeding. Petition, they have not filed in the affidavit in opposition, my lord. Based the entire case based on that, my lord. What was the denial? What were the conditions for the denial of the promotion?
But the records have been called for.
Yes, ma'am.
Yes, Dr. Muziga.
Well, I think the records are there, but it seems that they missed the brief, my lord. The matter is taken up next week, my lord.
On premium by the learned TSGI, not objected to by petitioner. This is matter after 1 week.
1 week.
Are you sure this court has called for the records? I have not.
No, I was supposed to produce the records, my lord. I'll produce it, my lord, on next day.
1 week.
1 week or 10 days, my lord.
Either 1 week or 2 weeks. 10 days.
2 weeks, man.
10 days means you have to give a definite day.
2 weeks, my lord.
2 weeks, sir.
Hello.
From supplementary cost list, item number 1.
Under this matter, with Lordship permission, we have filed additional affidavit, madam, on the 3rd, 5th.
Is that
bringing on record, my lord, the copy of impugned order.
Is it tendering case, not tendering?
Tendering case, my lord.
Tendering case, my lords.
Bringing on record the impugned order.
Okay. So, your contention is, if you file the, the 7 relevant notification in this petition, that would suffice.
Yes, yes.
They would say that you have to file separate.
As a matter of fact, I have filed a miscellaneous application, my lords, for deleting the names of the 6 other villages. Because the order impugned in these proceedings, my lords, are only 1.
Yes, but they are, it's a common order.
Common order.
It's not a common order, my lords. They're separate orders.
Separate order, but common.
Substance may be the same.
Substance
may be the same.
Only the name of the village is different. Localities. That is only
the proceedings were different. There was separate evidence led, and there were separate orders passed.
It's the same, my lord. Same petition, my lord. Same hearing, same order. Date also same order.
Proceeding same.
The same, my lord. Yes, the same. And lordship is sitting in the writ jurisdiction, my lord. Equity jurisdiction.
It is in writ jurisdiction. As a matter of fact, the same issue was agitated in another matter, whether by way of a supplementary affidavit, my lords, a challenge to the substantive writ petition can be made. Well, that was answered in the negative.
You have the order there?
Well, I have not brought it. As a matter of fact, the matter came up when your lordships were sitting in division bench. Single judge had passed an order, division bench upheld that order, matter was carried to the Supreme Court. Supreme Court has also passed a similar order. The orders passed by this Honorable Court was upheld.
What is the order?
If
it has some relevance here.
Because, what happened is... Well, they filed the affidavit. Your lordships had permitted me opportunity of filing a reply to this. Since they just served it yesterday, my lords, I have not been able to file a reply. I'll pray for a week's time, I'll file a reply. In the meantime, my learned friend can also file replies to my miscellaneous applications, and your lordship may hear them.
Otherwise, it is a substance are the same. Anyway, lordship may kindly do. And my friend may produce the judgment.
But perhaps it's a issue of a procedure and formality.
It's a pure issue of procedure, my lords. It's like this, my lords. If two matters, my lords, 2 writ petitions are heard and disposed of by a common judgment by your lordships, in appeal, my lords, I cannot file a common appeal. There has to be 2 appeals.
Would be.
That's the law, my lords. As a matter of fact, even that has been adjudicated by this Honorable Court in Division Bench. So they cannot say, my lords, merely because the substance is the same, that they would file an affidavit. If my learned friend wants to pursue this matter, my lords, I have no grievance.
See, because the rights per se, are exclusive.
Lordship.
So it would not be covered. What is accorded to one cannot may not be applicable to you. Vice versa, whatever.
Well, lordship may kindly see whether, my lord, the content of the each impugned order will result to different conclusion. Then it is my duty to file it, my lord. What happened, my lord, when they serve a copy, district council serve 1 copy only. And there, my lord, 1 village name is mentioned in other villages. So therefore, we got the impression that only single order is there. Subsequently, district council brought to notice of this court. Therefore, lordship granted permission, and we place it now on record. So lordship kindly see.
See, Mr. Sangresu, as an analogy, more often than not, as Mr. Paul has rightly said, if there may be cases which are similar in nature, emanating out of the same, notification or impugned order. For example, that Priyanshi Marat case.
Well,
the one you had.
Yes, we have.
So it refers to a common, common order, so to say. But 2 separate petitions were filed. This court, or any court for that matter, would deem it, if it deem it fit and proper to pass a common order, then it will. Thereafter, the process follows. So similarly, in this, but you have reversed the.
It's the other way around.
Because they serve us only a single copy, therefore we got that impression.
So, you see, if it is a matter of formality, then do it.
But even if we refile, my lord, it should be the same thing. We can do that.
Like I said, you see, if you say so, the order may be a common order. What we do usually, you see, when a dictation is given, when order is passed, next case is same as the other one. It could be like that.
That is since the lordship is sitting in equity jurisdiction, whether the objection raised by my friend carry weight. Definitely, my lord, since I'm the one who invoked the writ jurisdiction, procedure-wise, I should be clear also. But for me, my lord, it remains the same. Therefore, we pray for that. Since we received copy from my friend yesterday, the miss case for striking out, matter may come after 1 week. If we decide,
We'll exchange pleadings, Malus.
Yes, we
And
can
your
file
lordships will hear us on this issue.
Yes,
2 weeks.
Miss case listed.
So we go to the miss case.
Miss case, whether it is not listed today.
This case is not listed.
Is it listed today?
It's there with the main case.
I think it's part of the
Main case.
Listed.
No, you were.
The orders can come in the.
You are referring to the orders which should come in the
In the writ petition itself, it can. The orders can come in the
Mr.
writ.
Paul,
My lords.
this is your application for striking out.
My lords.
So you will respond to this.
My lord, I have received, my lord.
Okay. So we'll pass an order first in this miss case 62. You appearing in this case, Mr. Paul?
My lords.
Allow us to take instruction, my lord. Not necessarily filing affidavit also. Take instruction, my lord. For instruction.
Mr. H.L. Sangriso, learned senior counsel appearing for the petitioner, has submitted that he is in receipt of the application registered as miss case number 62 of 2024, filed by the respondent therein.
Respondent number 4, 5, 7, 8, 9, and 10.
10.
Respondent 4, 5.
5 to 10, my lords. 5 to 10.
Exactly 6 is not 5 because the 6 we have in annex is impugned order in the petition.
So 4,
4, 5, 7, 8,
4 is all.
9 and 10.
4, 5, 7, 8, 9,
9, 10.
respectively.
1, 2, 3, 4, 5, 6.
It is prayed that sometime may be allowed for
instructions
to be received and for necessary steps to be taken, even to the extent of filing a counter affidavit. So that liberty will be given to you. Either you take instruction. If you feel that you want to file a response, do it.
Right. And Lordship may kindly record that we have filed the additional affidavit. Bring on record.
No,
in the main case.
That will come in the main case. So I'm a simple-minded man. Don't confuse me. Otherwise, if I go here, we are on live TV. That's a main case, bro. Mr. Sagrisul, senior counsel, has submitted that an affidavit has been filed. Bring you on record. Relevant 7, is it?
Yes. Impugned copy of the impugned order passed by this council with regard to respondent number 4, 5, 7, 8, 9, and 10.
Copy of the impugned order passed by the respondent KHADC as regard the respondent number
4, 5, 7, 8, 9, and 10.
4, 5, 7, 8, 9, and 10 respectively.
Along with the petitions.
Mr. K. Paul Leonard, senior counsel, appearing for the said respondents 4, 5, 7, 8, 9, and 10, has submitted that he may be allowed to file a response to the same if so instructed. Then next
2 weeks, please.
On pre-made by the parties, this is matter to 2 weeks.
Yes.
Obliged.
Item number 2.
What is required here?
But we're arguing on maintainability, my lord. So
Yes,
Mr.
what is required? I mean, what is the matter fixed?
The state is to Mr. Bhattacharya.
Well, it was argued by the petitioner. Thereafter, my lord, in the other case, it was argued on behalf of the state by Mr. Gautam, my lord.
So it appears that you may be on the same side with the other respondent, but
yes,
cross purposes.
Yes, my lord. So,
My lord, in fact, the two revision, my lord, one filed by State Sports Council, which is I am petitioner, my lord, and there Mr. Bhattacharya is the respondent, my lord. There is representing state. The other revision is filed by state where Mr. Keshav.
Yes, he is appearing.
He is appearing for state. So, my lord, Mr. Bhattacharya's stand will be same as our stand, my lord. We're supporting our case.
True, but let's not confuse the matter. Stick to a particular case. You may see, as I from time to time used to observe, you may say the same thing.
Yes.
It will be recorded, related to the particular case. So it will not become confusing later on.
Yes.
As far as this is concerned, you are to respond.
Yes, my lord.
Mr. Sangwa has responded.
So, my lord, otherwise I am supporting the case of the petitioners, my lord, here.
Simply saying that will not do.
But however, my lord, there are certain things which I wanted to point out to this honorable court, my lord. So, my lord, only one request, my lord. Today I may be allowed to point out a few things, my lord. But as far as there are certain citations, my lord, my apologies, I don't have it today. But for that, if some time is granted, my lord, I'll.
You can, okay, first you advance your oral argument.
My lord.
Then you can file your written argument and incorporate whatever, or you may, the court may allow you another time for you to advance, cite those authorities. That's up to you.
So, my lord, what has happened is that my lord is well aware, my lord, that.
But please make your stand clear so that it will not be confusing. This is 21.
Hello, this is 21, my lord.
As far as 28 is concerned, matter is over.
Yes.
Your for respondent.
My lord, here I am for respondent number 2 and 3, my lord. 2 and 3.
Yes, please.
So, my lord, what had happened in this instant case, my lord? The Sports Council has approached his honorable court, my lord, because there was a, my lord, direction from the honorable court below, my lord, to transfer a certain amount of fund to the account of the, my lord, respondent number 1, my lord, the then respondent number 1. So, my lord, even our stand is that, my lord, that the Sports Council is not a party in the proceedings, trial proceedings, or in any of the proceedings which was before.
You are the director sports.
My lord, I am for the state as well as the director sports, my lord. So, my lord, my thing is that suppose, my lord, one person, one entity is holding 2 posts, my lord. Irrespective of that, my lord, the 2 posts are different functions, my lord. They cannot be brought in together, my lord. When I am dealing with the affairs of the Sports Council, then I am holding responsibility of the Sports Council department, my lord. And as a director of the sports department, this is an individual function. My lord, the chairs, these are 2 different chairs, my lord. Individual may be one. One individual may have several responsibilities, my lord. But it does not mean that, my lord, that the other department or the other office could be held liable for making a certain payment, my lord. Now here what had happened, my lord is well aware that this is a case where it originated from the assistant to deputy commissioner, my lord. There was a certain suit filed, and thereafter, my lord, it culminated into, my lord, this order which was passed, my lord, may kindly bear with me. In favor of the respondent, that is at 54 to 70, 52 to 74.
Page?
My lord, this is page, my lord, 52 to, as per the index, my lord, it is 52 to 74. 52 to 74. But this is that case which is before the assistant to deputy commissioner, my lord, money suit number 24 T of 2009, my lord. Yes. Yes. It was a long judgment, my lord. So, my lord, the last order is that, my lord, under the above, that is, if I take, my lord, to page 74, my lord. Under the above facts and circumstances, my lord has reached the page. Under the above facts and circumstances, the suit is decreed in favor of the plaintiff as against the defendants. I hold and declare that the plaintiff is entitled to a sum of, my lord, 1 crore 50 lakhs 73 so and so, my lord. Yes. From the defendant's department. I further hold that the plaintiff is entitled to get interest against the aforesaid amount of rupees so and so only at the rate of 12% per annum with effect from 1/4/1998 till 31st/12/2009. So, my lord, this was the original order which is passed, my lord, which was passed. Subsequently, my lord, my lord, against that order, the state had filed in the first appeal, my lord. So even that first appeal, my lord, was also dismissed, my lord.
Where is the?
My lord, that is at page, starting from page, my lord, my lord, the relevant page is at page, the last part of the order is page 101, my lord.
It starts from page 84.
Or it starts from page
FAO number 10 of 10T 2013.
Yes, my lord. By order dated so and so, learned additional DC Shillong, this matter was re-endorsed and made over to this file for its disposal, as this court is now been empowered with the power of additional deputy commissioner, and accordingly the case was received so and so. What are the last part of the order, my lord? It's 101.
Para 23.
Yes, my lord. From the discussions as above, from the I may be allowed to read from para 22, my lord. Last but not least, on the ground that the respondent should have proved the case beyond reasonable doubt, as the evidence brought on record was not sufficient to pass judgment and decree in favor of respondent. From lower case record, it reveals that the learned trial court had not proceeded ex parte. So there was a finding, my lord, that the had not proceeded ex parte against the appellant's defendants despite their failure to file written statement, though with the ample time offered upon them for 1.5 years. But the defendants were given ample opportunity to take part in the proceedings, where the plaintiff, while providing her claim in the plaint, has filed evidence on affidavit with as many as 10 documents exhibited in exhibit so and so. That apart, the plaint was cross-examined thoroughly by the government advocate on behalf of the. Anyway, these are the observations, my lord. So finding is at 23, that from my discussions as above and at the outset, I therefore find appeal of the appellants is devoid of merit and the same is dismissed, thereby upholding the judgment and decree so and so passed in money suit number 24T of 2009 by the Court of Shri M.S. Sangma, the Assistant to Deputy Commissioner Shillong, parties to be at their own cost. Appeal stands disposed on contest. So, my lord, appeal was filed, thereafter review was filed. But my lord will kindly see in all these proceedings, my lord, who are the party, my lord. My lord, if I draw my lord's attention to page 84, my lord, FAO number 10 of 2013.
Yes.
My lord, in kindly see who is the party. State of Meghalaya, represented by Commissioner Secretary, Sports and Youth Affairs Department, Meghalaya Chilo.
Yes.
So, my lord, it is a known fact, my lord, that a party who's not anywhere there in any of the proceedings can, my lord, a blanket direction or order can be issued, my lord. So they have rightly approached this honorable court, my lord. Could have been, assuming that I am the same person.
You mean to say that who are the parties in the money suit?
Money suit, my lord, the parties of the state of Meghalaya. I'll take, my lord, again to the order in the money suit, which is the original order, my lord. That is page 52, annexure 5, my lord.
Yes, yes, so Director Sports.
Director of Sports, my lord. No, Sports Council is nowhere a party, my lord.
Okay.
Sports Council is nowhere a party. Now the question here is whether any such order could have been issued, my lord. A blanket direction, my lord. What the order of the execution says, my lord, if I take, my lord, to judgment order.
So the execution is thrust upon the Sports Council?
Yes, my lord. That is at page annexure 9. No, which is the order dated?
Where's the execution?
Trial court in money suit execution.
Well, page 144, Lord, so kindly see,
144. 28.4.
Yes. So this is what the
Now, my lord will kindly see.
Yes, yes. Tell me.
To the branch manager at HDFC Bank.
Take notice that as per letter dated so and so an amount of rupees 14 crores so and so is only lying in the bank account of the judgment debtor. My lord, how this trial court reached the conclusion that it is lying with the account of the judgment debtor, my lord?
Then it says under the name of Secretary State Sports Council Meghalaya with your branch.
My lord, prior to the trial court coming to this conclusion, my lord, there has to be evidences has to be laid, my lord. Can a trial court, my lord, come with a blanket order that yes, you are the same person, it is lying in the different account, so you are the judgment debtor. So can the court, my lord, without any leading any evidence, any trial, my lord, straight away come to conclusion that this amount is lying with the judgment debtor, my lord? That itself was.
But this issue was agitated in the second appeal, isn't it?
No, my lord.
No.
After this we came by this, my lord.
This after the second appeal, my lord, the execution proceeding went ahead after the second appeal, my lord.
Well, Lordship will see this is dated 28th April 16, my lord. This execution order at the bottom of page 144, and the second appeal order, my lord, will see page 129. The High Court's order is dated 20 April, my lord, 129 page.
My lord, this is dated 24/2016, my lord. That is
High Court order is 20th April, my lord. You will also seen that. Page 129. Not even a week has gone, my lord. And this is what trial court did, my lord.
Now, if I take.
Of course, there is no. See, there's no hard and fast rule that.
My lord, certain directions were given by High Court, my lord. whether those directions were complied with by the trial court, my lord. They stayed away within 1 week, my lord.
To look into those discrepancy as far as duplicate entries are concerned.
My lord.
My lord will kindly see another aspect, my lord. That is that if I take my lord's attention, draw my lord's attention to page 141. And this is an order passed by the trial court below, my lord, learned trial court below.
Most importantly, my lord, the lordship has seen the decree was 1 crore 50 lakh rupees, my lord.
My lord, exactly.
Now, lordship, page 144, your lordship sees, my lord.
Now we are switching to
14 crore rupees,
stereo mode.
My lord?
We are switching to stereo mode. From mono to stereo.
Just to point that out, my lord.
So, my lord will kindly see page 141.
Yeah, what is it?
Yes. So, my lord, if I am allowed to read, my lord, a suit for recovery of money value are rupees, so it has come to 8 crores something, my lord. So, out of 1 crore such and such amount, it came to this much. 88 lakhs, this is rupees 8 crores, 88 lakhs, 44,824.
This is taking into account the interest component?
Yes, my lord. Now, can it be, my lord? It cannot be, my lord. The actual dues, including those accrued till 31st/12/2009 and from the date of institution of the suit till the date of decree and thereafter till the realization of the decretal amount from the defendants. So, the Honorable High Court of Meghalaya, by order date and so and so, passed in RSA number 5 of 2016, modified the judgment and decree dated 19/8/2016, passed by this court, and consented decree is to be prepared as per order dated 24/2016 of the Honorable High Court. The suit has been remanded back to this court, is coming on the day for final disposal before so and so, Shillong, in presence of Shri Arun Mukherjee, Advocate, Counsel for the Plaintiff, and Jyoti Marak, Advocate, Government Counsel for the Defendant. So, my lord will kindly see, this is a new counsel for the government. I was through and through there, my lord, till the second appeal. So, suddenly, my lord, there is a different counsel is there, and there is a consent also given, my lord.
Perhaps the government pleader must have exercised his discretion.
My lord, in my respectful submission, my lord, the counsel was perhaps not even aware of the case. There is a matter which is being dealt on for several years. So, my lord, suddenly a new counsel comes and gives consent, my lord. So, my lord will kindly see. Ordered and decreed that pursuant to the order dated so and so, Honorable High Court in RSA 5 of 2016, a consented modified decree is prepared. Accordingly, the plaintiff is entitled to a sum of rupees so and so only from the defendant department. The plaintiff is also entitled to get interest against the aforesaid amount at the rate of 12% per annum till 31/12/2009, rupees 1 crore 40 lakh so and so, my lord. Only and also with effect from 1/1/2010 to 24/2016 of rupees, sum of rupees 7 crores 29 lakhs 75,926. Only till the passing of the order dated 24/2016 of the Honorable High Court. The disputed amount of rupees so and so.
Where does this 7 crores 29 lakhs came from?
My lord, here it says two components, my lord. One is the plaintiff is also entitled to get interest against aforesaid amount at the rate of 12% per annum. So, with effect from 1/4/98 till 31/12/2009 of rupees 1 crore 40 lakhs 32 so and so, my lord. This is one component. Okay. Only and also with effect from 1/1/2010 to 24/2016 rupees 7 crore 29 lakhs.
So this is also the interest?
My lord will kindly see. Only till the passing of the order dated 24/2016. The disputed amount of 21 lakhs 98,930 only an interest accrued thereon till date has been excluded pertaining to bill number so and so 1157 to 1230, which requires fresh adjudication as directed by the Honorable Court, and that the sum of rupees 9 crore so and so only be paid by the defendants, that is by Commissioner and Secretary, Sports and Youth Affairs Department, Shillong, and Director of Sports and Youth Affairs, Government of Meghalaya to the plaintiff, Srimati Dios Marbiniang, at the rate of 12% per annum from the date of institution of the suit until 24/2016. My lord, what is the basis of the calculation? How the amount has been derived? My lord, these are the facts, my lord. This honorable court has to go into, my lord, in my respectful submission. Why, my lord? This is public money cannot be squandered in this manner, my lord. Technicality, my lord. Mere technicality cannot defeat the case, my lord. We may say that as per procedure, this should have been done, that should have been done. But what is the bottom line, my lord? Bottom line is squandering of public money, my lord. Can public money be squandered in this manner, my lord? This court has every right, my lord. When it comes to maintainability, my lord, this court has every right to see that no amount of, my lord, government exchequer is wasted, my lord. If I am entitled to something, my lord, I am entitled to 1 crore. I am getting 9 crore, my lord. Can there be any justification? Even assuming, my lord, that the case is very, very badly fought, my lord, it was not properly taken care of, let's say on behalf of the respondents, even for a moment, my lord. But kindly see, my lord, can the money be wasted in this manner? Now, my senior has subsequently filed, my lord, the affidavit saying that these regarding the accounts of the Sports Council Department, my lord, the bank accounts. My lord, he has filed 2 affidavits. But my lord, will kindly see, all this should have been, if there was any such material, all this should have been looked into by the trial court. Evidences will have to be laid. Conclusions cannot be drawn without evidence, my lord. So, my respectful submission, the trial court was grossly illegal in passing this order. And this order wherein stating that judgment debtor, in the account of judgment debtor, 14 crores is there. Judgment debtor, even in the last order, what it says, the last paragraph, and that the sum of 9 crores so and so, only to be paid by defendants, that is by Commissioner Secretary, Sports and Youth Affairs Department, Meghalaya, Shillong. Which is the direction to the Sports Council, my lord? Sports Council is nowhere in the picture. So even, my lord, even assuming that the director has done it on purpose, let's assume, my lord, though not admitting, that I have so and so amount in my money, account in my money, in my bank, say 14 crores I have. Let's say to avoid, for a moment, let's assume a situation that to avoid this execution, my lord, let's assume that I have transferred. But even then, my lord, there is a certain procedure. You cannot issue a blanket order. You cannot say, once it is in different head, different account, different entity altogether. So there is no such order could have been issued. At best, my lord, you should have, the other party should have made proper application that this fund is gone to some other account. A proper procedure should have been adopted, my lord, rather coming to a straight finding, my lord. However, my lord, however convincing it may be, my lord, trial has to proceed, then only then, my lord, conclusion. Otherwise, my lord, in my respectful submission, my lord, it could amount to biasness, my lord. So, my lord, this court, in as far as maintainability is concerned, my lord, whether this court has the authority, my lord, yes, definitely. Here, my lord, the defendants or the respondents are challenging on the ground of technicalities, my lord, that this should have been followed and they have not done this. But my lord will kindly see the larger picture. The larger picture is misuse of public fund. It cannot go unnoticed, my lord. And my lord, this is the fittest case for this honorable court to interfere, my lord. Let us assume a situation, my lord, this court does not interfere. Then what will happen, my lord? This money is gone, lost. Now, whether the party who is receiving the money, does that party actually earn that money, my lord? My lord, I am entitled to 1 crore. I am getting 9 crore. My lord, who will be accountable for that 9 crore, my lord?
If as has been pointed out
My
by
lord,
the trial court, if that 9 crore is born out of a proper set of calculation, there's nothing that can be done.
my lord, but my lord will kindly see.
As I remarked earlier, the interest component is to be taken on.
My lord,
it's an interest of 12%.
My lord, now the problem is, my lord, what is the manner in which the 12% interest is calculated, my lord? whether in any proceedings, whether what is the amount, how it is to be calculated, what is permissible limit, whether it is simple interest, compound interest, but how that figure came across, my lord, came about, my lord. So, my lord, in my respectful submission, my lord, this court, honorable court, has to go into the matter, my lord. My lord will kindly see the larger picture, which is misuse of public fund.
Let us see. But you see, more often than not, in matters of this kind,
my lord,
the court is bound by the letter of the law.
But, my lord, that is why, my lord, there are.
Otherwise, you see, let us try to distinguish here. If it is a writ jurisdiction, it's a different thing altogether. This is a supervisory power that is.
My lord, that is exactly why, my lord. This is superintendence of this honorable court, my lord. So, my lord, this honorable court is is to guide, my lord, that whether these things can happen or not. My lord, otherwise it may set a bad precedent, my lord. That any days, let's assume a different situation, my lord, different parties. But, my lord, let's assume that one person is holding two posts. Again, similar direction can be passed.
That is a different thing.
Lord, it could set a very bad precedent, my lord. So there are, that is why, my lord, as far as certain judgments, I came across a few, my lord. So I will pray if this honorable court allows me time.
So you do that.
So my primary argument is based on this, my lord, and the facts which are brought on record by additional affidavit, my lord, that in respectful submission cannot be taken into account. If these are there, then there should have been a part of the trial, a certain separate trial proceeding ought to have been initiated, my lord. This is my respectful submission.
Yes. My lord, may I add a few submissions, my lord? My lord, the most glaring aspect of the entire case is, my lord, Lordship has seen the original decree of the trial court, my lord. Lordship kindly notes down, my lord. This is very important. Page 74, Lordship will see the original decreed amount was 1 crore 50 lakh rupees, my lord. Page 74.
Page 74?
74.
Yes.
The decree amount is 1 crore 50 lakh rupees, my lord.
Yes. Yes.
Now, my lord, Lordship kindly turns to page 141.
Yes.
The modified decree, my lord.
This modified degree of 8 crores.
So, my lord, here, my lord, I want to point out one thing, my lord. 8th line, my lord, the disputed amount of rupees 21,98,000. Page 142, my lord.
Yes.
So, as per the direction of the High Court, my lord, the disputed amount
Yes.
almost 22 lakh, my lord, 21,98,000. So, if we deduct 22 lakh from 1 crore 50 lakh, my lord, the remaining amount is mentioned here on the first line, my lord, page 142.
Yes.
1 crore 28 lakh rupees is the decree amount, my lord. Now, my lord, we'll see interest is given in the fourth line, my lord.
Yes.
From 98 till 2009.
Yes.
And also with effect from 2010 to 2016. So, my lord, the interest is given from 98 to 2016, that is 18 years period, my lord. And rate of interest is 12%, my lord. So, 18 into 12 will come to 206%, my lord. 216%, my lord. So, 1 crore 20 lakh rupees, my lord, plus 200% interest will come to 3,60,000 only, my lord.
200, how? Where did you get a 200% from?
My lord, the interest is given, your lordship has seen from 1/4/98 up to 24/2016, my lord. So 98 to 2016, my lord. 99 and year 2000, 2 years, and this side is 16 years. So total 18 years interest is given, my lord. And rate of interest lordship is seen is 12%. We are not disputing, my lord. The 12% is higher or lower. We are not going to that question, my lord. So, my lord, if you calculate 18 into 12, my lord.
18 years into 12.
18 years at the rate of 12%. Because there cannot be compound interest, my lord. This is settled law. It has to be simple interest, my lord. 18 into 12 comes to 216% interest, my lord. So, my lord, 1 crore 28 lakh rupees interest, 216% of that. At the most, it can be 4 crore rupees, my lord.
Troubling it.
At the most, it will be 4 crore rupees, my lord. What the court has decreed, my lord, your lordship kindly sees on the next page. Page 143, my lord. Yes. 9 crore 98 lakh rupees, 98,000. At the bottom, my lord. My lord, the biggest problem here is serial number 8, my lord.
Yes.
The interest is calculated at 7 crore 29 lakh rupees. This calculation itself is wrong, my lord. 43.
Then you should have filed 152 petition, eh?
My lord, 152 is one aspect, the way it was executed thereafter, my lord. Because if we had not, if this honorable court had not passed interim order at that point of time, my lord, it was impossible to secure the money, my lord. After we came before this honorable court, my lord, this honorable court granted a stay order. The money was reverted back from their account to UCO Bank, I think. And the money has been secured by this honorable court, my lord, about 5 crore rupees. Those orders are there, I can refer to those orders, my lord. So because of the orders passed in these proceedings, my lord, the money has been secured by this honorable court, my
lord. But is this the stage or the forum where you can revisit the calculation?
My lord can remand back for recalculation, my lord. Your lordship can definitely do that. But till then, execution has to be stayed, my lord. Recalculate the amount.
If that is the case, of course, it stands to reason.
My lord.
Execution has to be stayed until the final amount is determined.
My lord. Even if your lordship does not go whether 1 crore 28 lakh rupees was the correct amount or not, even if you don't dispute, in under 227, your lordship will not go into that aspect. But your lordship will definitely go into that aspect whether 1 crore 28 lakh rupees, can it become almost 10 crore rupees, my lord. And not only that, my lord, lordship sees page 144, my lord, here what it says, my lord, first sentence. Take notice that as per letter number 20, an amount of 14 crore rupees, my lord. How the money is increasing, my lord, day by day?
No, this is the balance of the, I think if I recall correctly, it was pointed out that this is the balance that was there in the account of state debtor spots, or was it?
No, my lord, here it is straightaway written judgment debtor. But it could not have been judgment debtor, my lord. That okay, itself is grossly.
That nomenclature may be a misnomer.
It itself is,
so my lord, in my humble submission, the matter can be disposed of by very short order, my lord. If lordship remands back this order only, my lord, page 141. Just 1 second, I'll just complete. That reduce their amount, they'll definitely be concerned. There is error apparent on the face of record, my lord. And my lord, moreover, my lord, your lordship always has the power. If lordship feels that 227 may not be maintainable, your lordship has the power. I can place so many decisions on that. Your lordship can convert into 115, my lord, looking at the public interest involved, my lord. One 115, your lordship can exercise any power, my lord. And moreover, this is from Deputy Commissioner's Court, my lord. This is not from normal area of Shillong also. And that point of time, CPC was not strictly applicable also, my lord.
Yes. This is under the rules.
Under the rules, 1937 rules. So Lordship simply sets aside this order, directs the trial court to within 1 month recalculate the amount and then execute whatever. State, it cannot be that state will not pay the money. It is rightful amount, 3, 4, 5 crore, whatever they are entitled to. But it cannot be 10 crore, 11 crore rupees. And that much money has already been paid to them. They actually executed 11 crore rupees, my lord, the entire amount. Now this honorable court has secured the balance amount, my lord. Now those are fixed, and there is a direction that without the leave of this honorable court, they will not touch that money, my lord.
You have to come up with the relevant authorities.
Yes, my lord.
As the power of this court under 227 in situations of this nature.
In this nature, my lord.
That would be more.
My lord. We'll place that. My lord.
Yeah, similarly, they would also counter it.
My lord.
Oh.
My lord, in my respectful submission, my lord, this is a perfect situation, my lord, for this honorable court to interfere. But nevertheless, my lord,
these are under rules, my lord. Lordship can treat this a revision under 36A also.
36A, no doubt. But that you see that Drusilla case has been overruled. Otherwise, in revision you can always go into the facts. But now that gate is closed.
Lordship can even treat this as an appeal also against the execution order, because the powers are wide under the rules, my lord. I'll try to place some more decisions on that aspect also, my lord.
There are decisions,
but a simple direction will suffice, my lord. The trial court to recalculate the amount.
There are also decisions, my lord, where, my lord, a question of justice is there, my lord. My lord, technicalities, my lord, should not be gone into. It should not be strictly gone into, my lord.
See, the illegality or irregularity has to stare you in the face.
My lord, here it is staring in the face, my lord, in my respectful submission.
So
we cannot say everything in court, my lord.
If you want to respond with, you've got the gist of their argument. If you want to respond,
and as far as these affidavits,
with relevant authorities, oral argument is not required.
My lord, and as far as these affidavits, as I've earlier stated also, my lord, they have no relevance in this case, my lord.
That is.
But once the amount is reduced, what has been executed already from the state government, that will suffice, my lord. They are not entitled to any further amount.
That is the problem with the world. You see, the more we get, the more we want.
But at least, my lord, the one should be legitimate, my lord.
There is a saying. It says this: enough for everyone's need, but not for everyone's greed.
Greed, my lord. That is true.
This is exactly the case.
I'm not casting aspersion anyway.
This is exactly the
any
case.
party.
So, my lord, as far as legitimate claims, my lord, it's a different issue.
That will be looked into.
My lord.
So when do you do it?
My lord, for written argument, I'll pray for some time, my lord, along with the citations. Okay. If it is listed after.
But you do one thing, Mr. Saji.
My lord.
You've given advance copy to the.
Yes.
Also to Mr. Sawan, and he'll respond.
Not. May I pray for 2 weeks, my lord?
Heard Mr. Saji, counsel for the Leonard G, appearing for the respondent, state director of sports. Director.
My lord. Respondent 2 and 3, my lord.
2 and 3.
2 and 3, my lord. I mean, for the state, my lord. So one is for.
Yes, one is. I mean, the state is always a formal party.
My lord. So 2 and 3, my lord. Respondent.
The Leonard G has also submitted that he may be allowed to file just of the argument in written form, along with relevant authorities relied upon. Mr. CCT Sangwa, counsel for the respondent number 1. Has something that he may be allowed to. Why would the respondent number 1 contradict you?
My lord,
You're on the same
main
side.
contesting parties are these two, my lord. I am anyway supporting.
We are replying to, they raised the maintainability, my lord. We are replying to that.
That apart. That apart. Also, like to respond. If so, instructed. Or pray me, this is matter up to 2 weeks. Maybe 3 weeks. 3 weeks.
Obliged, my lord.
Item number 8.
Please, Your Lordship. Lordship, I pray for accommodation, Your Lordship, in this matter, Your Lordship.
Why? What is this matter about? Subsidies?
Subsidies.
Yes, Your Lordship.
On pre-made petitioner? This is matter of the 3 weeks.
Item number 10.
Lordship, my argument is ready, Lordship.
You have also filed yours.
Yes, Your Lordship.
So, in spite of this, nothing has, come up as far as the, settlement is concerned.
Lordship, there is nothing with regard to the settlement, Lordship. They are agitating on on their rights that they have paid, and Lordship, in some of the cases, it is like, Lordship, according to the today, actually I thought I'll file only written argument. According to the 7I, section 7I, Lordship, which is very clear, if they are not ready to settle, then the appeal lies before the appellate authority. That
one.
Lordship,
that provision is there.
That provision is there.
14.
14B 7Q. 14B and 7Q, just particularly appeal lies before the appellate authority. So I have already, I have placed everything on written argument, and my affidavit also says so. That we have repeatedly told them, Lordship, that if any grievance is there against section 7Q and 14B, then they can prefer an appeal before the appellate tribunal. And moreover, when they came before this honorable court, they were seeking accommodation for settlement also, but nothing has come up, Lordship. When we freeze their account, they have till now, after your Lordship passing order to defreeze their account, they have neither paid, they have neither.
Yeah, I think that was a condition precedent, that they, on the freezing of the account, they are to, pay the current dues.
Current dues, but nothing has come up, Lordship.
They have not done so.
Lordship, nothing has come up, Lordship. They are all agitating on.
Just Miss, can you point out to that order? Is there any condition of that kind when the account was defreezed?
Account was defreezed.
You have a copy of the order? Because this will involve you. The amount is with your bank.
No.
You have to assess the court, miss. Otherwise, if that condition is there, and now you are stating that they have failed to do so in spite of this court direction, that would be, that would have a bearing as far as the court's observation would be. An inference has to be drawn.
Lordship, the Lordship, they are disputing on the amount, Lordship, but
we are not talking about the past amount. What we are talking is the current dues as on the date of the order.
Lordship, the current it is so happening, Lordship, now after the order is passed, Lordship, unless and until the financial year ends, the audit happens, date to date it is difficult to find out, Lordship, because it is all through after audit it comes up. But the Lordship, after the Lordship's order, they are supposed to pay apart from penalty, they are supposed to pay other dues, Lordship, which they are not paying, Lordship. Because the amount is with regard to the penalty and damages, Lordship.
But where is, like I said, just point out if there's a specific direction in that regard. Otherwise, if it is a general order, then nothing can be done.
Lordship.
Or is there any miscase filed?
No, Lordship, there no miscases filed, Lordship.
Lordship, this order dated 21st of June 2023, Lordship. Lordship, with regard to the defreezing of the account, Lordship, there was a direction for that, the outcome of the said meeting, because the meeting was supposed to take place between the two parties, Lordship.
Yes.
The outcome of the said meeting will determine the action of the respondents number 1 to 3 as far as the process to defreeze the account of the petitioner's bank account is concerned.
Yes, of course. But what exactly is the relevant order?
Lordship. Then they were supposed to have a meeting, Lordship, but it appears that no meeting had taken place.
Yes. And even if
meeting took place, but
even if the meeting had taken place,
but
no headway was reached.
Yes, Lordship, it did not work out, Lordship.
No, Miss, have you pointed out in your written argument this aspect of the matter? Where is that order? Accounts, please.
Lordship, 2106 in para number my written argument para number 15, I have pointed out that that it is most respectfully submitted that the petitioner, after passing the order of defreezing of the account wide order dated 2106/2023, never took any initiative towards the payment of interest and damage imposed upon them, which proves the adamant behavior of the petitioner and also not taking the court order seriously.
So that was the order Ms. Sheila pointed out.
Lordship, that's the order that was pointed out by the bank, Lordship.
Just a moment.
But Lordship, with regard to defreezing, it was supposed to be on the outcome of the said meeting, Lordship.
Yes, but
there's no direct order for defreezing the accounts.
then how was it defreezed then?
Because even for the meeting to take place, it took some, I think, 4 to 5 days, Lordship.
There must have been some specific order, otherwise how would
I'm not getting it on my website, Lordship, the High Court website.
I recall vaguely that a specific order has been passed, but where?
May I assist the court, Lordship, if I may go through the orders of by this Honorable Court?
What I'm doing, you will also do the same thing.
Actually.
Unless you have X-ray vision.
No, Lordship, I think you're more blessed that way.
No, I'm also going meticulously through each and every order. There's no specific order. I think there is no specific order. I know.
There is no specific order, Lordship.
Except it may have been a just a verbal observation. But how can it be?
How can that be, Lordship, without an order passed by this Honorable Court?
How can it be that you have defreezed the account without the order passed by this court?
Lordship, actually.
Now the onus is on you.
Lordship, I'll have to seek instructions as far as that is concerned, Lordship, because to my instructions, Lordship, I'll have to find that out, Lordship.
Please.
Lordship.
It's very pertinent because
It's quite surprising actually if there's no specific order.
I'll post this matter for 1 week.
Lordship.
Please find instruction and
Lordship.
Ms. Rochester, please find out because I can find nothing from the order sheet.
Exactly, there's nothing, Lordship. Except for
But how? But why it was? Now you're saying that the account has been defreezed.
Account has been defreezed.
Miss
Lordship, there was Lordship somewhat. I also remember, Madam, before Madam entered appearance, I think that account was defreezed.
That is why you have to.
I had the appearance on the 3rd or the 4th day, Lordship.
You find out from the bank.
I'll find out from the bank, Lordship.
Miss Pivarchaji, learned counsel for the respondent 1, 2 and 3 has filed the written argument. However, on a query made by this court as far as the issue of defreezing of the relevant account with the concerned bank, oblique respondent 4, the learned counsel for the respondent 4 would submit that some time may be allowed to seek specific instructions in this regard. As prayed for, seems allowed, list this matter on after 1 week.